Dissertations, yeah, Mark 2. I always have to check that everybody's in the right place. Please come on in. Open the window, it's incredibly stuffy in here.
Yeah, so hot.
Although we do have to contend with the drill. Right, so welcome back, second half of the dissertation support class. Hopefully, the first hour was a helpful introduction to your dissertation module, what we expect as part of the dissertation research process, and you are making good progress with respect to finding out what in the world it is that you want to research, even if you haven't necessarily started writing anything just yet. So the first time around, we generally looked at how, and what I wanted to convey to you is that don't compartmentalise this process, don't over-engineer process, drive this process too much. Okay, get straight into the research and the writing as soon as possible. Identify what the issues are through your preliminary research and start to construct your dissertation, and be prepared to be persuaded, I think is what I said a number of times last time around, that when you get into the research and you really start to analyse the issues and what's been written, the arguments that are being made that you want to report on, don't go to that body of materials with a preconception of what that argument is going to be. It may well be that through the process you'll identify an issue that is much more interesting, exciting, and there's more to discuss than you first envisaged. And it may well be, and I recall doing a similar thing when I done the dissertation as well. And indeed, when I was at the Law Commission as well, we thought we had a pretty good idea of how the law was working in practice, and when we actually got the consultation paper back, a lot of the respondents were saying it was working in the completely opposite way. So we had to rethink at the Commission's position, and the same process you should be adopting for your dissertation. We went through various sources, most of which will be patently obvious to you. But I conveyed the fact that you by all means, for example, utilise, please come in, by all means utilise the online resources that you have available. Okay, use your LexisNexis for legislation, make sure you're looking at the most up-to-date piece of statute, or timestamp the statute if you're looking at for something, the development of a particular principle as it has manifested itself through that piece of legislation over time, and use Westlaw for cases, LexisNexis and all those electronic resources which are very, very helpful, because of course if you simply just Google and rely on the first page results, that's not good legal research practice, and you'll want to know, for example, where a case sits in terms of its jurisprudential value, before placing too much reliance on it. And with respect to online resources, journals, articles, newspaper articles, again very helpful for good current affairs, but you wouldn't, for example, use something that even the FT is reporting on, where it's a matter of law well established that you can refer to, the Act of Parliament or a piece of European legislation on that. Then, of course, there is. Then there's the need to really start to get down your literature review. That is sort of identifying what has already been written on the subject matter, maybe forming part of your first couple of chapters, just setting out what those issues are, such that you would then go on to analyse those issues and present your findings in later chapters. And then so today I'm going to just spend a bit of time on methodological approaches to legal research. I try not to send you all to sleep when doing so, and there is a qualification to that discussion I wanted to really set out at the outset, which is, whilst I will refer to sort of within the academy how we would describe the process by which you would evaluate your sources for the purposes of your dissertation as a socio-legal, okay, or a historical way of evaluation. I don't want you to get too hung up on clearly articulating that methodological process, but use this discussion, okay, as a way of focusing on the correct materials. Okay, so if for example, maybe part of your overall dissertation, or maybe one particular aspect, simply requires you to identify a particular law, okay, or governance around behaviour, and you only need do that with reference to statute, case law, and so on. So you're telling your reader what the law is, and you're not necessarily going into the analysis, the critical examination of that law for the purposes of your argument, your hypothesis. You would only use a specific approach, and then you would leave that analysis piece to a slightly different approach, which I'll come on to. Anybody thinking of doing interviews, questionnaires? Okay, make sure you liaise very closely and as soon as possible with your supervisors if you want to do so. When we're looking to identify the materials for our dissertation, we can do a documentary analysis, which is what most people will do. Okay, you may do some research by observation. You may do some research by interviews, you may do some research by questionnaires. But we'll go on to some health warnings with respect to that. And of course, it's not a PhD you can do over a number of years. So we'll have to think and work closely with your supervisor to see if you can get enough out of your interview or questionnaire process within the time constraints that you're having to operate to. Okay, so I'll come on to that for those that are thinking of doing so. Then we'll touch on structure of research papers. Okay, so whilst I've talked about legislation, case law and so on, but you may well look to a law commission paper or an article in a journal for evidence, and we'll talk around how best to approach those, what to look out for. And of course that really speaks to what I sort of wanted to major on today, which is more the practical side, conveying some of the experience that I've got in doing a lot of legal research over the years, which is essentially tips for good research practice. Okay, to try and bring some method to the madness that is legal research, so that you can be quite focused. Okay, and just to ensure that you keep on point and you use your time most effectively during the process. And as always, please interrupt me with any questions or concerns as we go through, okay? Because rest assured there's 2 or 3 other people in the room with probably a very similar question. So, methodological approaches to legal research. Right, so if we talked about identifying all the various sources, which are the inputs that you're going to use to tackle your research question and present it in a logical, persuasive form in your dissertation. Okay, you're going to need to apply a methodology to that evaluation. So that's what we mean when we're talking about research methodology. Okay, and you use that to produce the results. Now I'm going to talk about whether you do a quantitative assessment or a qualitative assessment. Okay, quantitative was generally anything statistical. It can be reduced to numbers, or qualitative when you're talking about the meaning of the words, the values, the expressions. Most of what we do obviously on an LLM dissertation is going to be qualitative in nature, but you may well seek to to demonstrate a particular point with reference to the results of an interview, questionnaires, or other statistical data available. But essentially, a lot of the way in which you'll go about your research process will be quite inherent. I mean, everybody here, this is a master's degree, okay, postgraduate, all of you would have done legal research in the past, okay, and it's quite innate in the way that you will naturally go out and do the research, okay. You might start with a simple Google search. You'll identify a law firm briefing. It may well refer to a law commission paper, which in turn refers to various articles. You go to those articles. They've got footnotes and citations in as they're going through a particular discussion. You can go to those referenced materials and so on and so forth. But as I said at the outset, let's talk about the more defined approaches and think about how you can use this as an idea to broadening or getting a slightly different angle through which you can, or lens through which you can look at your research question. Okay. So it's important to have a clearly defined methodological and theoretical approach to evaluating that evidence, which is capable of answering your research question or sub-questions. Okay. Evaluation is central to how you answer your research question and informs those materials. So obviously, if we're looking to apply a historical approach, then you're going to naturally look, for example, I gave the example earlier on of utilising the LexisNexis tool, okay, to look at a particular act as it was initially enacted, say the Financial Services and Markets Act in 2000-2001, and then you can look at the Act and what the corresponding provisions was saying in 2005, again in 2014, and then the current one. That's approaching your analysis from a historical perspective, of course. Now, whether or not something is qualitative or qualitative is less about whether or not you can reduce it to numbers or not, but it's more about what you want to do with that information and the claims that you make on the basis of it that determines whether it's qualitative or quantitative. And we don't require you to identify. I am going to do a doctrinal analysis here. It can be quite implied. So at the end of this lecture, I'll put up on the screen the dissertation that I submitted some 10 or so years ago, or 7 or 8 years ago, to give you an idea of sort of what it looked like. And you'll notice that the structure that I chose didn't specifically call out the methodological approach in a paragraph, subheaded paragraph. Others have done so, and that's perfectly fine. It depends on how you wish to structure your dissertation. Okay. So we'll talk about some of these. So the doctrinal methodology, social, legal, comparative, historical, and of course you can use interdisciplinary methods as well. But whatever you choose, make sure it's valid and reliable. So doctrinal, for those that have done undergraduate law degrees, of course, will probably have referred to this as a black letter law. So that's where you seek to explain the technical or coordinated legal rules. So you'll look at what the law is doing in terms of its manifestation. Okay, where do you find it? What's the rationalisation for the law? Okay, and you'll use that with a view to identifying gaps, uncertainties, legal risk as well. It tends to be a precursor to the analysis in that sense. Okay, so the Law Commission will use a doctrinal approach to identifying what the law is, and then it may use a socio-legal approach to see how it's acting in practice. Okay, very good, of course, that you would have used a doctrinal approach if you've got a problem question for your MOAs. Okay, so for those that remember the support lectures that I gave when you started the LLM, for your MOAs, make sure you advise the client if you're given a factual scenario and how the law, as it is in practice, is affecting them. Don't get drawn into a discussion on political, socio-economic, and what the law ought to be. Okay. So you would have, in doing that, adopted a doctrinal approach. Hence, you probably didn't realise that that's what we would call that approach, because it's quite an inherent process from your legal training. So the premise is that each case, for example, forms a part of a system of rules internally connected and related to each other in distinct groups. So you'll concentrate naturally on the legislation, cases, work of other scholars describing the compilation of the law on that particular subject matter. You'll aim essentially to provide a comprehensive account of the law for a particular topic. Okay? So you might look at specific rights and obligations of a particular legal doctrine and how they've been assigned through judicial interpretations on the meaning, scope and requirements of the law. Okay? So what you'll tend to use this approach for is if you're actually criticising whether or not there is too much legal risk, whether the law is not sufficiently clear, whether you need more of a binary process, whether there are uncertainties, whether there's the application by judges. I gave you an example for that. If in your area there is a Supreme Court case or any judicial decision that is passed by a majority, always go to and read the dissenting judgment. Okay, because these are members of the judiciary, experienced lawyers, and they're disagreeing with their peers, no doubt for very good reason. So it's an excellent source of ideas, a basis on which you might critique, the current state or the accepted position. Cross-reference to cases, rules, principles, axioms, identifying where the law falls short of a formalist idea. Okay? But the limitations of doing this, of course, it doesn't look at how the law is acting in practice. Okay? It doesn't involve criticism on moral or political grounds, for example. Now, we're doing it in LLM, and I said at the very beginning last time around that we have to make sure there's a legal hook. Okay? Do make sure that you ground your dissertation on an issue that speaks to how the law is creating that issue, or is part of the solution to that issue, or how it may not be the solution, but you could use the law as a tool to remedy an issue that you've identified. But nevertheless, in isolation, okay, it may not be fit for purpose. So you may want to look at how moral or political issues are impacting the law. I mean, you might take, for example, dare I use the B word, Brexit, okay? If you're looking at a financial services question and how firms are being required to make sure that they have financial resources, contingency plans in place and execute on those contingency plans to ensure that they can provide a continuity of service to their clients post-Brexit, when we don't actually know what Brexit means and what it actually is going to look like if it's finally agreed. It's very, very difficult for firms and presents a lot of issues, a lot of legal risk for them. And you might want to get into a discussion of how Parliament has sought to legislate to provide for temporary or transitional provisions, and then how the regulators are monitoring and supervising those, for example, all of which are going to have political connotations. You're going to have to do some scenario analysis, and it isn't necessarily, it's not going to present the full picture if you just simply say this is the statutory instrument, provides for a transitional period, this is what a firm needs to do, for example. But of course it is good for a focused study with clear boundaries and the materials are readily available. Okay, so if you're looking, to introduce issues of, morality, ethics, policy, politics, it's sometimes difficult to identify where to go, what the boundaries should be for that. Whereas if you're just doing a doctrinal analysis, you haven't got to consider those issues. So to my point earlier on, it may well be that the doctrinal type analysis, what the law is what's currently there, will be good for a particular subchapter or chapter in your context setting, for example. Okay, and it may not be sufficient when you get into the analysis and challenging chapters. So the disadvantage is that it ignores moral and political issues, risks oversimplifying, and is only a limited grounding for law reform. A good doctrinal study will display knowledge of the law, cases, relevant scholarly works, and cross-reference to materials, and engage with those legal arguments and theories. So, of course, you can use that analysis and then go on to discuss the implications. So, socio-legal, there's no agreed definition, but it generally includes both empirical studies of the law in action, okay, and the theoretical work on the law's various functions within society. So, is the law, okay, guiding behaviour in, prohibiting, prescribing, proscribing behaviour in the way that it was intended? Is it being used, as it was intended? And so, of course, when you're looking at this, you may look to Hansard, for example. Does anybody know what Hansard is? So Hansard is the official record of proceedings in the English Parliament. Yeah? So you can access the Hansard records, the debates in Parliament are recorded and so on. And they're very interesting to read through, because of course that was the debate that preceded a bill, okay, which then preceded the Act of Parliament. Okay, if you're looking at a particular provision of law. So it's interesting to read through what the intention, what the concern was, such that it ended up manifesting in a piece of legislation. So essentially it's concerned with a contextual study of the law and legal systems. So clearly addresses some of the perceived deficiencies, because it can provide an opportunity to consider the consequences that follow from your doctrinal analysis, the manifestation of the law. Okay, whether or not it's appropriate for a particular objective. Have they, for example, imposed a criminal offence when an administrative sanction would have been sufficient? A corporate failing to exercise reasonable steps to avoid tax evasion or bribery and corruption. Okay, they're now criminal offences on the statute book. Debate as to whether or not that actually does anything to dissuade people from doing those acts, or whether it's fair to impose that sort of obligation on a corporate. But of course it does and can lack clear boundaries and a straightforward methodology. Where do you start? Where do you end? Quite a few of you may well be thinking about a comparative approach to your dissertations. The obvious example is jurisdiction versus jurisdiction. Okay, but it may be cross-sectorial. So you may be looking at the consumer protection tools, the way that the law goes further with respect to transactions and interactions with consumers versus business to business, and whether or not some of the protections that are in place for business to consumer relationships are good, and what's the efficacy of imposing them for B2B, for example. So it's not just simply of comparing, what the US is doing to the UK, what China is doing to South Africa. You can think broadly. Just obviously you have to identify a clear correlation and corollary between the two comparative aspects of your dissertation to make it worthwhile. Okay. So generally what you're doing is you're looking at how different legal systems or legal cultures have addressed particular legal problems, and with what degree of success or failure. Okay, so you can include a purely doctrinal and a more social-legal, but always take account of the differences in context. So, of course, if you're looking at comparing, the UK to the US, you may well do, a chapter on what law is in the UK, another chapter on what the law is in the US, and then you have an analysis, a comparative chapter or two. Okay. Equally, you could split and structure your dissertation by issues. So at the beginning, in your context, and after your literature review, you've identified issues A, B, C, and D. You then structure the remainder of your dissertation to deal with chapter that deals with A, and then you look at the position in the UK, US, analysis, conclusion. Issue B whatever the comparative jurisdictions, depends on how you want to build the structure. So a doctrinal approach using the comparative methodology might concentrate on how one jurisdiction has addressed an issue of legal uncertainty that remains problematic in another jurisdiction. Okay? So I don't know, you might be looking at how the UK Parliament required a change in terms of individual accountability for regulated activities in the UK, and how the Australian Royal Commission is now looking at the same thing, and the Kiwis are now looking at how the Australian Commission's work is going to impact on them, and whether they need to change the way that they license firms, for example. Okay, so you can trace through the issues across jurisdictions if you want to do so. A social legal approach might assess the impact of a legal provision in one jurisdiction to inform the implementation process in another. Hopefully you can spot the subtle difference of methodology between those two. But as I said, don't just pick a jurisdiction and compare them. In your introduction, same professional approach that we do for MOAs, when we're advising clients and you're producing the MOAs, you need to scope the boundaries of your dissertation. So state, if you're comparing a number of jurisdictions, spend a few lines to saying why you're using, India, Europe, US, and Australia. That is almost certainly going to be too many jurisdictions. We've only got 10,000 words, and not the DRC, for example, and why. Okay. The aspects of the law to be examined. Okay. The aim of the analysis, essentially going to be lessons for improvement, one versus the other, blueprint and not. The objective, how you'll achieve that aim, so you'll explore similarities and differences and so on. And structure, as I talked about, you may just do one jurisdiction at a time, or you'll just take issue by issue and then cover off the discussion that way. Good advantage of using comparative work, you can use existing knowledge of another legal system, you can use both doctrinal and social legal methodologies as good basis for legal reform strategy and policy. So when I was at the Law Commission, for example, we were looking at the fiduciary duties of investment intermediaries. There's an awful lot of law in relation to fiduciary duties of those intermediaries. There was statute, there were statutory duties, there were common law duties, there were equitable duties, and then we also asked experts from Australia to give us a paper on what that actually meant in Australia and in a couple of other jurisdictions as well. Very helpful. Disadvantage, access to relevant materials. Okay, so you may want to use a particular jurisdiction, we'll stay on that as a comparative, but can you actually access the materials? Do you have a sufficient knowledge of the legal system to know where to look? Okay, is the law translated into English such that you can evaluate it in an official capacity, or can you get a translation through other means? It'll take you a while to just put it through Google Translate, I'd imagine, but can you really rely on that, for example? Okay, and you do risk producing a descriptive dissertation, so it may be great to look at a number of different jurisdictions, okay, but you're going to have to describe the manifestation of the law in each of those jurisdictions. That's going to take up space and time. Okay, so you'll have to think about whether or not you're going to have enough space to do so. Talk to your supervisors whether or not you can, you should limit it to 2, 3, or more. A historical. So you might reconstruct and evaluate a legal topic or issue from an earlier period in history. So, principle of good faith. The extent to which it's been absent from the statute books in English law, with the exception of the insurance market. And that's had the principle of good faith coded for a number of years, over a century. You may look at my favourite topic, fiduciary duties, and how that has been developed over time. Okay. spectrum of methodologies again is available to you. A doctrinal example might be you trace the development of a norm over time, gaining an insight into its present day. Social, legal, historical context of the emergence, development and reform of the law. So what is going on? What's the policy? What are the issues in practice in society that is driving the fact that, we could no longer leave the City of London Financial Services to govern itself, 1986, deregulation, okay, a number of different scandals resulted in the full codification of regulated activities. Why was that? Why was that needed? Okay. Then why did the tripartite system between the Treasury and Bank of England and the Financial Services Authority break down? Why was it reformed in 2012, for example? You trace it through time and you can identify the issues. Again, access difficulties, in-depth study to fully understand the historical context, so it may well take some time, obviously. Difficult to avoid arbitrarily identifying the time frame. So that example, I started at 1986, okay, the Financial Services Act. But why did I not start earlier than that? Okay. So again, that's just about scoping the boundaries of your dissertation. So if you just choose to start at a particular point in time, explain why that is the case, and it's a good place to start. You don't need to labour that discussion too much. Okay? Questionnaires. Yeah, a very useful source of primary data on specific topics. If you can introduce new research in the process, that's absolutely fine. But you can get a distinction, okay, without having to stand out by collating brand new research. Okay? Right? So don't feel like you need to do that in order to yeah.
The questionnaires have to be focused only in view of like raising or trying to come up with new information. I'm asking this because, for instance, the questionnaire that I'm trying to spread out is fashioned in a way that is going to bring out the ideas of people to actually know if they think something is actually a problem.
Okay. Right.
So maybe, for instance, if you like chocolate cake,
yeah,
with a lot of sugar, I think maybe I'll think that it's healthy, and you think there's a problem with it.
Mm-hmm.
So with the way you answer it and the way that I will answer it, to actually find out what people in that community think about it, and people in another community also to think about it. It's not really to bring out something new, but then to find out how they appreciate the validity of
to try and get an original data source on the feeling or the interpretation of a particular issue or topic. Yeah, I mean, I mean, absolutely, you can use it for that basis. The challenge that you'll have is essentially twofold. Is what's your population, and what's the sample of that population you're targeting, and then if you get responses back, which obviously we would hope that you would, to what extent can you rely on that response as being representative of the population that you've looked to? And then secondly, you talked about a very open-ended approach to the question, so inviting people to convey how they feel about a particular topic. That's fine, but you could put out 50 questionnaires and get 50 different responses. Now that may be perfectly fine, depending on what you want to use those responses for. But if you're looking to, for example, draw a conclusion that represents a particular position, you may find, given that you're using open language, that it would be difficult for you to compare one response to another. Maybe you should think about using predefined answers. So select from the following drop-down menu, for example. Yeah. So most closely, would you associate with? Because that way you will then have, you'll corral them into a particular decision. Now that in itself is going to be, you'll have to think about whether that undermines the process or the inference or conclusions you want to draw from that process. But it does mitigate the risk that you waste your time in putting out the questionnaires, getting responses back, and they're so disparate and unstructured that it's going to take a while take a while for you to digest it.
So to actually take control of it before you decide.
Yeah, so that's what I talked about. So if you're going to do questionnaires and interviews, you absolutely have to identify the population, identify the target sample, be ready to defend the fact that sample is representative of the population. Yeah, and pilot the questionnaire. Always helpful, because if you could probably get away with a lesser formulaic process in the context of this LLM dissertation, okay? But there will be questions asked of the process if you place too much weight on that. Certainly, if you were doing that as part of the PhD, it would have to go through ethics committees. It would have to. That's what you need to liaise with your supervisor as well, because you've got to think about issues of ethics as well as bias and other heuristics when you're canvassing other people's opinion. Because, say for example, I wanted to do an interview, okay, and I wanted to know what your propensity might be for insider trading, okay, and I gave you a scenario, and I'm trying to elicit your risk appetite, whether you'd go for it because you may not get caught, and so on. Or if I asked you what your firm's code of conduct means for you, okay, and I'm trying to get your genuine opinion on it. If I conducted that interview whilst you were sat next to your line manager, okay, in the office, or in the office generally, I'm likely to get a very different response than if we had a discreet coffee in prep next door. Yeah. So you have to think about biases, inherent biases, when you're canvassing opinion. So whilst it's I looked at it, trying to do some questionnaires, and I didn't end up doing it, but because I essentially found the results of somebody else's primary research, and they presented it in a certain way, but they also allowed you to download the raw data, and then I downloaded the raw data, and then I could manipulate it to demonstrate what I wanted to demonstrate, which wasn't what they used it for, but it was available, and so I could get the result that way. But it's definitely a method that you're welcome to think about and adopt, but speak to your supervisor whether or not we can facilitate it and make it happen.
Yeah, in regard of interviews, if there would be possibility to be connected with people like who are with whom this issue of elicitation is relevant, but they are from techie side, not from legal. Yeah, would it be relevant to get from their interview?
Very difficult question to answer, because the answer could be both yes and no. I mean, if you're looking at if your dissertation looked at the use of smart contracts on the blockchain, and you were looking at liability after a smart contract had executed, I'd imagine you would want to canvass the opinion of those that coded the smart contract, and what conditions, preconditions, and other factors were intended to be built into that. At the same time as you would the counterparties to the actual contract, and at the same time as you would, lawyers that are having to to defend and prosecute against breach of contracts in that scenario. Now, obviously, the nature of the question you wouldn't put to the individuals that coded that piece of technology, whether matters of legal consequence.
Yeah, because it would be kind of weird. Yeah.
Well, they're not qualified to opine on that. So, as taking it at its highest. So it depends on what questions you want to ask of them.
Anyway, they could give insights about how the technical side to understand it.
Yeah, because it may well be that the inputs into the execution of it, and we've chosen a very specific example, but I'll keep with it. If the inputs into what will cause the code to execute on a smart contract you'll be taking data feeds from a number of different sources, and they'll be able to educate you on what those data feeds are, and how that is connected. So, say for example, that data feed is a latent data feed and it's not a real-time one. What's the impact on the execution of the contract in those circumstances? But as I say, great to think about it. But I think in the first instance, try to look for the easier option. So see if others have done something close to you, to what you want to achieve already. Okay, because they've done it, they've put the resources in it. Of course, you have to look at their terms of reference, what question they were seeking to answer, and how they went, and understand their methodology so that you can have faith in that methodology, or you need to take issue with it, for example. But okay, yeah, so your questionnaire should be structured the same for your interviews. Make sure you pilot it, think about the population as well. So you are going to need to try and standardise the approach as best as possible so that you get, so if you are going to canvass all of our opinions, there's no point in just, in a very informal way, have us answer questions over 5 minutes and then everybody else gets 10 minutes and somebody gets 15 minutes and you ask different questions. Okay, so we obviously need to standardise the process as best you can. Oh, and equally, if you do use it, okay, you should explain why you've selected the specific interviewees, okay, and include those persons who did not agree to be interviewed as well, because that might be a very interesting. If you wanted to interview somebody about personal account dealing and they refused, and your dissertation was on conduct risk, and whistleblowing or something like that, it might be, you might want to draw an inference from that. Not an adverse inference, but an inference over their willingness to talk about that. Maybe their refusal to be interviewed and talk about it because it was firm policy not to speak up, right? So it could be an interesting process. And so here was that potential solution. So you may well be able to find, tertiary data that has been collated through other research projects that you can use. So I refer to, for example, when we talk about sources, that you may find a dissertation or a PhD thesis that is very close to your subject matter. Okay, certainly if it's a PhD thesis, they've had 3, 5, years to go through that process, and they may have done a lot of interviews, and so refer to it, use it. So make sure you remove the irrelevant data, okay, and make sure you keep that semi-relevant data to a minimum. So research paper, okay, so there's no single approach to structure. I've said this in the context of how you might structure your dissertation, and so last time around and so far today I've sort of alluded to different approaches you might take to structuring your paper, okay. You fundamentally should be rewriting it as a research question, okay? And as you go through your literature review, your preliminary research will tell you that there could be a number of different issues to consider, and rewrite those as questions to make you go and seek out the answer and assess whether or not you can rely on it. You're welcome to include an abstract if you want to, okay? It's sometimes very helpful in a quick read to really, get the reader on on point with respect to what the paper is tackling. Now, of course, I talked about, I encouraged sort of my supervisees to try to articulate your dissertation in a sort of an essence of my study, yeah, which you won't be able to do particularly articulately now, because you need a few weeks to really understand the issues, and you might just do it in a very incoherent couple of pages. But as you focus on and you start the writing process, okay, look to summarise it and summarise it again and reduce it down to 150 words, 100 words. And that ultimately is not only helpful to ensure that as you go on you identify new sources and you're doing research per your chapters, that you can look at its relevance all the time, okay, so as not to get distracted on a particular tangential issue potentially. And then of course that essence of your study is perfect to just slot in at the beginning as the abstract, okay. So talk about what the issue is, how you intend to approach that issue, what the conclusion was. Okay? So it should be sufficient to explain to the reader what he or she should expect to find in the paper. Okay? Introduction. So make sure you include a sequential summary of the research work performed over the relevant area. Present the current study within the context of the previous research work and explain in particular why the study has been done. Okay. Include within your introduction an indication of the methodology if you wish to do so, or just leave it quite implied from the way that you've approached the structure of the paper. Okay. Do include, in the same way that you would have done for your MOAs, statements to the effect that this is the issue, this dissertation examines, okay, and will argue that ... Okay. It does not consider, right? The scope does not extend to the following, okay, because of these reasons, and so that could be the subject of further research, and therefore the dissertation will proceed as follows, and then you essentially signpost how the dissertation proceeds, okay. So then you can go straight into the structure of your dissertation. Make sure you include the results of your research. Okay. So, some students prefer to simply do a context chapter, so literally a literature review. Okay, in the first chapter. Okay. Then do a second chapter on analysis. Then do a third chapter on discussion, and then results and conclusion. Okay. In an analogous way to you would expect in a scientific paper, in a similar way. Okay, it's entirely up to you. But make sure you include the analysis. Okay. Oh, and in every single one of your chapters, there needs to be an introduction and conclusion. Okay. Yeah. So introduce what the chapter is going to be doing and conclude what the chapter did, and so it's obvious how it flows into the following chapters. All right. So it doesn't just look too disparate. Make sure you don't include any new analysis in your conclusions. Yeah, conclude on the analysis, and then do make sure you come back, okay, to what you wanted to answer. Those research questions. Ask yourself: Have I told the reader the answer as I see it? Okay, to the question that was posed at the beginning. And once you've written that, go back and rewrite the introduction. Because the introduction will, as I just described, tell the reader that is what your dissertation will do. Alright? You'll develop the appropriate structure as you go through. Okay, use the chapter structure to answer the research questions. I've suggested you might look to each chapter informing the sub-research questions. What's key, though, when you're going through the process of your dissertations, okay, is to really ensure that you're being prepared to be persuaded. Rewrite the question in light of initial research, okay. Use the citations and the reference material within whatever you're reading as a pathway to further research. Okay, so if you're looking at a journal article, you've seen all the citations, refer to those and read those articles. But obviously you need to think about whether or not they remain relevant to your essence of your study and your research question. Okay. Quick practical note, right? As you'll be going around, I don't know whether you've already experienced it or you certainly might, is that you'll end up having a plethora of materials. Okay, and certainly as you're going, going about the process, how do I prioritise myself? This is the technique I've always used, and I've always got my dissertation Word document open as I'm reading and writing every single piece of research. And so I always, if I come across something, I immediately assess it whether it's good, usefulness, or no idea of its relevance. So if it's good, it's going to relate to the essential context. Okay, it's authoritative. It's focused on the narrow issue that I've identified as relevant to my research question. Second of all, scope is narrow. There's a possible peripheral relevance. No idea of its relevance. I rarely will discard, throw away any particular source. There's a reason why you've come across it. So don't discard it. You may not appreciate its relevance, because how many times have you read something in passing and you've discarded it, and then a week later when you come back you think, I've read something about that, but I've no idea what I've done with it. Okay. So don't just simply locate the sources and describe their content. You need to include the analysis and critical thought. Right? Make sure you write as you read. So the way I've always gone about it is if I've located, and then obviously it's a very simple process if it's a piece of legislation. Less so if it's a journal article or you're assessing a report or a white paper or something like that. Always make targeted notes. So paraphrase what the paper is or what the source is, what's the objective, the idea or issue that they're discussing, is it relevant to me? Okay. Second of all, you read the notes and add the analysis. So what do you agree or disagree with and why? Okay, what's your reaction, sparks of thought? These issues are incredibly important, okay, because it helps you think about where your research is going to go, and it will be the opinion that comes out, okay? And what do you remain sure about? And then you just repeat that for, every single, and this is not over-engineering it because you're writing straight into the document, okay? So remember, record the full citation, the original source as well as the source that you're actually looking at. And then what you end up doing is you're having probably a chronological or sequential list of all the various sources, an article, a book, a piece of legislation, and you'll have them deal with different issues because you've recorded what issue that they're looking at, okay? And then you can end up essentially reordering your notes. So it's a matter of cutting and pasting and pulling together all of the sources that deal with a particular issue, okay? Read through those notes, identify those issues, reorganise your notes into the themes and issues as opposed to merely the chronology that you looked at them. Okay? And then that, coupled with your reaction and commentary on the articles or whatever the source might be, will form that analysis. Right? So your strong written work contains a lot of the stage 3 materials. Okay? So that was, what you agree with, why, your sparks of thought. Okay? And summaries of the stage 2, what they're saying, what the law is in that sense. Okay? So stage 2 is that evidence that you use to justify your stage 3. So what you end up doing when you're actually writing it is you put your analysis is presented first. So this is almost as if the paragraph says you already knew what the answer is. Okay? Right? We know what, this is the situation. This is because, Jones referred to this, or the piece of legislation states as follows. So then you include your evidence and support afterwards. Okay? And again, so continue to consider whether or not through the research, your research question and your analysis continues to be defensible in that sense. So if not, consider revising to align your research question, okay, in light of the literature. So I changed my entire research question about 5-6 weeks into the dissertation. Nothing was lost, it just meant that the research question spoke to the research that I'd done, rather than trying to fit the research into the research question, okay? Because nobody knows that you took left turn, a right turn and full turn during the process, and we just see the end result. All right? So we've run out of time, but I'll leave you. All of these slides are on the VLE, and you can read the summary. Are there any questions? No. Right. So we'll just still a couple of minutes, and I'll show you the document that I produced. This is the dissertation that I prepared some while ago now, and this was the title in the end. Okay. Now, obviously, it was initially a research question, and it never really dealt with regulatory arbitrage, and it wasn't looking at this particular market. I just knew I wanted to do something on securitization because I quite liked the subject matter. Okay. And so, when you're looking at the title, even without looking at the contents, you'd expect the author to have dealt with the reforms, define what regulatory arbitrage is. Okay, look at what the EU and US markets for residential mortgage-backed securities. What is a residential mortgage-backed security? So clearly, if your title is including terms of art and defined terms, you have to ensure that you deal with the definition of those. Okay, and then I ended up just structuring it fairly simply. Okay, the introduction, what the securitisation market was, what regulatory arbitrage was, the reform agenda, scope for regulatory arbitrage, which is what the question was. All right. And you can see here, so I was setting out the issue here, okay, and then stating here, so the paper contributes to academic reviews of the reforms, so stating what the paper did, okay. This paper considers whether the reforms are likely to, and then the two main benchmarks in which I done the analysis. This paper concludes that. So I mean, stating right at the outset what it's going to do. The paper's second hypothesis is that as follows. Okay, and I said at the end of here, so whilst the paper is instructive and provides a regulatory arbitrage from which to review the reform agenda, I know it's a lot of technical language, but it was speaking to my particular area. There remains ample scope for further study, and then I said the paper proceeds as follows. Chapter 2 does this, Chapter 3 does that, Chapter 4 does that, the paper's, yeah? So you can clearly see when you need only read the introduction, you know exactly what the paper's going to be doing. And the other thing I wanted to point out is that clear use of chapter titles, subtitles, however you want to do it. I actually find that numbering paragraphs is actually helpful too, but that's a matter. You can see I didn't do it here. But if you're doing a lot of cross-referencing, it's very helpful to do that. I always find if you can draw it, you understand it. Okay, no matter how bad you might be at drawing. So rather than just having something reduced to words, so much easier to understand. In the 10 seconds I've had that drawing up, I bet everybody knows what securitization looks like now. Okay, but that was something I did. To your point earlier on, I ended up trying to identify some data that illustrated the issues. So I obviously didn't do this research, but one of the Association for Free Markets in Europe did some data, and I just downloaded it, put it into Excel, and just produced the graphs. And then literally asking questions. I kept the subheadings. Why overly complicated? And then with reference, here's again all the citations here. Yeah. So the same approach you use for your MOAs, use for the dissertation in terms of citing absolutely everything where you're relying on third parties. All right. And it goes on. It's a really good read, I assure you. And again, so here's an example where I tell you this was. I debated on this. There was a lot to talk about with respect to this particular issue. I was running out of words. When I first drafted this particular paper, I think it was 18,000, something like that. Well, by my lectures, you can tell that I can go on a bit. And so I completely disregarded the word count. As I said, you should all do. Forget about the word count as you go through the process, and then get to the end, and then focus it down. Okay? And in the end, I just didn't have enough time, so I just ended up just putting it in a tabular form. Okay? Rather than discussing all the issues. And there's a lot of detail in there, and it was perfectly sufficient, but in the end, I ended up having to do a slightly different process. And then what did the I'm just scrolling down to the bibliography. Conclusion. Yeah, so the conclusion wasn't particularly long in the end. And then the bibliography. So I split it up, I think, I recall. So these are by alphabetical order, by the author of the article or the report, whatever it might be. And then I split out the statutes and conventions and the case law, regulatory and international reports. And that was it in the end. Yeah. But all of that was very simple to do. And of course, you can use bibliographic software if you wish. Yeah? Excited?
Not really.
No? More confident?
No.
Absolutely. Absolutely. No, it'll be good. So yeah, thank you very much for coming along. I wish you the best of luck with your dissertations. Enjoy the process. Yeah, make sure that you submit it on time. Make sure you sign the paper, everyone.
My title is also, I'm doing it in tax.
The tax, okay.
My title is also the impact.
Sorry, Barry.